Hey guys, welcome back. Today we're looking at the return of a certified Florida man I covered before. Somehow, he's come back even worse. Fewer brain cells, more chaos, and zero self-awareness. This time, he doesn't just embarrass himself in public. He goes straight into a courtroom and meets a judge who's not here to play games. And when I say this judge trolls him, I mean full-on legal humiliation. Every minute escalates, every exchange gets crazier, and by the end, you'll be wondering how this guy hasn't been locked up even more. Trust me, it only gets funnier the longer you watch.
This morning with your sovereign citizen argument, you needed some additional time to prepare.
Yes, sir.
I'll give you some additional time to prepare.
Both of them are back, and now we'll see if this guy learned anything from his last sovereign citizen stunt, or if the judge is about to teach him a very personal lesson. This judge has seen every trick in the book and is ready. What happens next is a courtroom showdown full of comedy, chaos, and reality checks. Buckle up. This one wastes no time.
Judge, I have brought to court with me during the recess the paperwork that was delivered by a private citizen for Mr. Morris. I have removed the binder clip that I had on it. There are no staples, there are no paper clips in the packet. It's simply a packet of prepared documents.
Okay. All right, Mr. Morris. Now that you have your paperwork, anything else you want me to consider?
Yes, sir. I'm looking through it now, sir.
Okay.
You'd think jail would have given him time to memorize his favorite phrase. Secured party creditor appearing specially, not generally. Nope. He's still the same clueless guy from last time. For almost 3 minutes, he just flips through paperwork, convinced the magic phrase is hiding somewhere inside. Watching this in real time? You'll need a facepalm helmet.
Common trust. Just speaking about the trust. This was the UCC, just financial statement. It's a UCC statement with my own Alizé Morris and the trust name. The principal name was Octavius Alizé Taquan Jeter. And then it says, this is the entry of collateral by trustee / secure party creditor on behalf of the trust estate. It's Octavius Alizé Taquan Jeter Trust in the commercial chambers under necessity to secure the rights, title, interest, and value therefore in, and the root or title from inception, as well as all property held in trust, including but not limited to DNA, cDNA, cell lines. There's I don't know what that word is right there.
Mr. Morris, I thought you said that they arrested the wrong person. The wrong person in jail. That's why I'm not sure what you're talking about some trust in your DNA and cDNA.
It says retina scans is what that said.
Okay.
I swear, these sovereign citizen types just get funnier every time. They aren't smart, but they are so condensed they crack some secret legal code. Watching their confidence crumble in front of a judge who sees right through it. That's not just funny, it's art.
Do we need to check your fingerprints or scan your retina to verify? Is that what you're asking me to do?
Oh, you can read this? I can't really read it like that.
Let me see. Maybe I'm not sure what's going on. You told me you were not Octavius Morris. Then you just started reading something from a sheet of paper that says Octavius Elise Taquan Morris.
Okay.
So are you or are you not Octavius Elise Taquan Morris?
No, sir.
All right, Ms. Smith,
my name, this is right here, sir. It's on. You probably can have a good chance reading it. Right here. This right here. Bill of service, tort and violation. Just had a judge look at this. I can't read all this stuff. Not to you. Alexander Moore, secure party, Billy, and principal of you or the agent fail not to, I don't know that word is right there. To your oath that should be called to answer before one God and the most supreme.
I can't hear you, Mr. Moore.
All this
Oh, sir, I want to call you Mr. Moore.
No, I'm not exaggerating. This guy now literally calls himself by his own made-up title and truly believes they arrested the wrong person. In his head, he's a living man, not the all-caps corporate name on the court papers. Today, we get the full sovereign citizen cinematic universe. Every buzzword, every loophole, and all the confidence that comes with being totally wrong.
Complaint affidavit here. And on December 5th, according to this complaint affidavit, Gulf County Sheriff's Department pulled you over while you were driving and arrested you. And they ran your name, Z. Morris, came back as a convicted felon. And are you telling me that your name is not Zatavius Morris, or you're not the person they arrested on December 5th? What are you telling me? Did you give a false name? What are you telling me?
I ain't giving no false name, Your Honor.
How did they get that name, Zatavius Elise Morris? Well, you don't answer that question. That probably has to do with, I'm trying to figure out, maybe Mr. Hill, you could help me. Is he saying that the Sheriff's Department arrested the wrong person?
Your Honor, as much as I can.
Well, don't disclose any confidential, privileged information.
I raised issues when I had my pretrial discovery meeting with Mr. Morris pertaining to this case, because that's the only one I've got discovery on.
Yes, sir.
And I've done some independent research into that. Mr. Morris, or this individual, has this information that he's saying that he is not the person.
I'll take a look at whatever you want me to. I'm looking at the complaint affidavit. They said they had your driver's. They said you had.
At one point, he basically admits he was driving without a license, completely unprompted. The judge sees it and realizes this isn't a legal genius. It's someone who watched too many internet videos. From that moment, the judge knows exactly who he's dealing with, and things only get better from there.
Restrict somewhere. You read the last.
Oh, I'm looking at legal notice and demand to all state, federal, and international public officials. This is a contract and admiralty. This is some of that sovereign citizen nonsense. I thought you were saying that they arrested the wrong person. I'm not listening to any of that sovereign citizen nonsense. You told me they arrested the wrong person. If you're talking about admiralty law and that the first page was a trust and that you're the debtor, I'm not listening to any of that nonsense. When are we coming back?
Your discretion, Judge. I can tell you I've got discovery on the first case. I don't have discovery yet on the second case. I'm at your discretion, Judge.
Ms. Smith, when do you want to come back?
Judge, let's do the 6/27, our next available, Your Honor.
Okay, we'll come. And Mr. Morris, I'm not trying to be disrespectful, but I thought you were telling me they arrested the wrong person. I certainly don't want someone who hasn't. If you're the wrong person that they arrested, I didn't want you sitting in the county jail. But what you gave me looks like some of that admiralty law, sovereign citizen. I travel, I don't drive.
You have to respect judges like this. He waves paperwork around and insists he has an airtight argument. The judge lets him talk, but as soon as it's clear it's just recycled internet nonsense, the judge shuts it down. No patience for fantasy law, no time wasted, and no taxpayer money burned.
You didn't get what I said? That was the agent of the principal. You know what I'm saying?
I think you're talking about a bunch of stuff that people who believe themselves to be sovereign citizens parrot, and I told you I'm not listening to any of that. I'm not sure how you, the principal and the agent of your own, I'm not listening to that. Now, if you are wrongfully arrested, that's what I thought you were saying. I certainly want to listen to that, but if you are talking about trust and being the agent, you're not the principal, and I saw something about admiralty law, I'm not listening to that.
What?
I will see you on the 27th of June. Take care, sir.
Lansing versus Laura Bacon, 2103207 OD. And you are Laura Bacon.
Yes.
Ms. Bacon, you are here for sentencing today, and we have a pre-sentence report with recommendations and a substance abuse assessment. Mr. Wornsley gave you that file so you could review it, is that right?
Yes, I'm confused by it.
Pardon, you're confused?
Yeah, because it said on there that I owe way more in fines and costs, and we've already paid them. That's first, like, and it still says I owe the $45 that he paid, and he has the receipt too, which would bring that down to a zero balance. That's in there.
I don't know what fines and costs you're talking about. It says you owe
For this,
St. John. You haven't been assessed fines and costs for this case yet.
it says on the thing I have. On the, so I don't know what he paid for, but it says it's for this charge. I'm just going by what's online and what was told to me.
I have not sentenced you. You have not been assessed fines and costs. You may have had to pay for your assessment. You may have failed to pay clearance fee, but as for
The case starts calm, but quickly the defendant argues about money she thinks was already paid. The judge cuts through it with clarity, showing the imbalance of power and how serious things are. It's the calm before the storm.
at the time of a plea in this case, which occurred after many, many times of absconding, you pled to a high VAC offense, which is punishable by up to 180 days in jail. Today is the date for sentencing. I have a pre-sentence report with recommendations, as well as a substance abuse assessment, which indicates that residential treatment would be the most appropriate treatment for
The
a
judge sets the stage for what's coming. This case didn't reach sentencing easily. There were missed obligations and repeated issues. The charges and potential jail time are spelled out clearly, with treatment offered as a last-ditch option. You can feel the judge preparing for a hard decision.
Yes, I want to spend my mom's last days with her, and I
Okay,
said,
that was not the question I asked.
no, what do you mean? I'm confused by
Is
all
there
that.
anything in this that needs to be changed to be accurate?
No.
Okay. What would you like to tell me on your own behalf?
My mom, I don't know. I have no idea what's going on with her, only by what I've been seeing before. I want to spend my last days with her. Again, sober, obviously, I will pay the consequences of my actions. I feel that way. Probation or alcohol tether. I don't really want to drink anymore. I feel like way better. Like I got healthier. Like, I don't know, my body feels better. And then I've got a lot of things like my HUD, I've got my UIA, and I have till like this week to get all that done or I lose all of that, plus my social security. Plus there's like everything happened at one time. I was going through it with my mom. Alcohol's not to be out. It's not. It's gonna kill me anyways if I don't stop.
Well, I mean, the fact is, drinking isn't going to make your mom better, right?
No, not me either.
It doesn't. It doesn't fix that problem. All it does is keep you from feeling the feelings that you have to feel about it. But Ms. Bacon, your conduct in this case has been abhorrent. You have absconded over and over again. You've never complied with bond. You make excuses for it. Your response to the assessor, the way you responded to them, as recently as 10 days ago, you say you got cleaner in the jail, but you were already in jail for a month when you saw her, and you still acted the way you acted.
I was confused by what she was asking me. She's like, I said, is this now in the jail or at the end of the assessment? Because when I was going through the assessment, I was foggy in my head the first time. So she had called me on the polycam on Friday for the other Friday. I think it was 2 Fridays ago. Yeah. And I asked her, because I just woke up and they just taken me off my, what do you call the program they put you on, the pills in the jail when you, the protocol for alcohol abuse. They had just taken me off of those. So I got.
This is where the defendant starts to lose credibility. The judge points out past non-compliance and challenges her explanations. Her excuses only make it worse, and it's clear the court won't accept promises alone anymore. Tension builds. The court wants action, not words.
That was a miscommunication between that. So then I answered them again for her. Because I thought, she was like, are you sure? Are you sure? And then I was like, does this apply to now or does this apply before I went to jail? She's like, this applies before you went to jail at court when you went in to see her for like the second time. So I was just confused. And then I started answering the questions how she wanted me to answer them because I didn't know how that's what it applied to, like everything. I thought it was just alcohol, not everything. The drugs, the marijuana, and then the alcohol. I thought it was just alcohol that she was asking about. Because it's all like messed up in there. I've seen that too.
Then the hammer drops. The judge rejects community treatment, citing unsafe behavior, and gives a 180-day jail sentence. Every fine and condition is read aloud, making the consequences crystal clear. Early release is possible, but only through strict compliance. This is the moment where past choices hit hard.
Okay. All right. For this case, while residential treatment is recommended, probation, the assessor don't believe that you'll participate in residential treatment based on your prior conduct, you would probably abscond from residential treatment. So I don't believe that we have the ability to, I guess, do the treatment in the community with you at this time, but your behavior is unsafe. So consequences and treatment are the appropriate response. Your sentence is 180 days in jail with credit for 42 days. You may be released upon completion of the CAT substance abuse program. So if you complete that program, you may be released early. Your fine for this case is $25, a $75 crime victim rights fee, $50 state minimum cost. That's $150 plus $404.12 in Lansing Police Department cost recovery, which makes the grand total $554.12 in this case. I did the math and it looks like you'll have to be in jail another 108 days unless you finish the CATS program. So I want to set up a payment arrangement with you today if we can, or you can report to court immediately upon release from jail to set up your payment arrangement. Pardon? Ms. Bacon, what payment arrangement do you want to set up, or do you want to come in and set it up when you get out?
Yeah.
That you want to set it up when you get out? Okay. I can put that on here, that you're going to come in and set up your payment agreement when you get out, but a couple things you need to know. Firstly, you do not have to have a dollar on you to come in and set up a payment arrangement. You can come in with no money and talk about making payments, small payments if necessary. But you do have to come in. So if you get out of jail and we find out you've gotten out of jail and you haven't come in to set up payment arrangements, they're going to want me to send a bench warrant out for you. In addition, I have these other tickets that are show causes. They say you still owe 129 on one, 160 on the other. I can just send those to the same person when you set up your payment arrangements for all of them, so that you can set up one big payment plan for everything that you owe money on right now.
Okay.
Bacon, since I gave you jail, I must tell you, you have the right to appeal your sentence. If you'd like to appeal your sentence and you need a public defender to assist you, you need to make your application within 14 days, okay? Mr. Rowley, whatever happened with Mr. Henry's, I think, was referred to your office. Did he follow through or did he get denied? How did that work?
I was just looking at that. I didn't see that this case has been assigned to anyone. So
Did he make the application?
I think he was denied once and was told he could reapply. I think I was told he could reapply, but I don't see any record that he actually.
Attention shifts to a second defendant, and the tone sharpens. His vague answers reveal hesitation. The judge asks bluntly, "Do you actually want to go to jail?" The exchange shows that delay and avoidance can be just as damaging as outright defiance.
I sent an email,
Come up here for a second. Sent an email to who?
to what the lady told me to email.
Who did? Come on, into the well. I gave you a phone number, I believe. Did you call the phone number I gave you?
No, she said I could email or call, so I emailed.
But I told you to call.
I thought I could do both.
Henrys, do you want to go to jail? Is that what you're trying to do? Because, I mean, the recommendation is you're supposed to. That's not great.
Well, I called lawyers too, but then they were just too much.
So I'm referring you to the public defender to see if you can get qualified, because lawyers are expensive. I think people have a misunderstanding of how expensive lawyers really are. I did that job. It's expensive. Okay. Mr. Henry, do you want to have an attorney with you?
I think I'm just gonna get denied like the first time.
Well, how could we possibly know that if we don't follow through?
Well, I make like 2 months.
You think so?
I'd make like 1,600 to 2,000 every 2 weeks. I work 7 days a week.
Okay, and you can't afford a lawyer for a probation violation with that amount?
Well, they fund it. I don't have that much saved up. I still like pay bills and I just paid the court fees.
Yeah, it's not interesting to me at all.
I was gonna see if I can do like weekends, like 120 days weekends.
Hell no.
Pay some fines.
No, that's not how this works. We don't do jail on your schedule. You don't do your probation, you do jail on my schedule. Mr. Henrys, you have had a significant issue with following through. This case was not small, or I wouldn't have put you on probation for it. You were driving around at a .21. You could have killed people. So you either address the issue and be serious about it, or you do the time. Those are your options. I guess since you got arraigned by the magistrate July 21st, so like 3 weeks ago, have you done anything to start complying with your probation?
I don't got my PO. I think I got a new PO. So.
Mr. Hanna. He's been a PO here for a couple of years. He's downstairs on the 5th floor. You could go see him right now. I don't understand what your problem is.
I'll go see him. I just didn't have the number. I didn't even really know I got a new PO.
Did you even try to find out though? I mean, you can tell me all that, but if you don't come to the court, you don't come in here and ask, you don't call the probation clerk and ask, then how can I feel bad for you? You do nothing in order to find out this information and then complain that you don't know. That's not how we deal with life.
I just have a hard time with these things.
So I'm gonna adjourn this 1 week to August 21st at 9 o'clock. 1 week. Go downstairs, talk to Mr. Hanna about whether you're gonna get yourself in compliance. I don't know if Mr. Hanna's down there, but if not, the probation clerk will get whoever's on to cover him, because they cover if somebody's off.
Is it like all the way in the front? Like at the bottom floor? Or?
5th floor, so 1 floor down. Says probation. We're gonna print you a new notice for next week. In this week, you may follow up with a lawyer. You shall speak to your probation agent, and you decide if you're gonna do probation or jail. That's what you're gonna do in this week.